So I will be discussing the basics of trademark, copyright, and patent law. And before I get started, I just want to premise this discussion with the fact that we understand that most Legal Corps volunteers are corporate lawyers. So we don't expect you to be experts, and we provide lots of resources for you so you don't panic when an IP question comes up. As was stated previously, we have the book, Starting a Business in Minnesota, that has chapters on trademarks, copyright, and patent law. And we also have, in most clinics, we have booklets on each topic. And also, too, when I was volunteering, I always recommended clients to visit the intellectual property lawyer that volunteers in the St. Paul Clinic the first Tuesday of each month. Sorry. Okay. I like it a little taller, but okay. All right. Compromise. Okay. So, with that being said, one of the most frequent IP questions we get is trademarks, and a lot of clients, as we kind of mentioned in the mock client interviews, get confused with registering a domain name, with filing a trademark, with registering their business name at the Secretary of State's website. So, however, clearly they're all different things, and registering a business name is a great way for the business to be identified within that particular state. But registering for a trademark is a different and more complicated process. So registering one's business name with the Secretary of State merely protects that name from being used by another business within that state. Furthermore, just because the name was available at the Secretary of State's website doesn't mean that the company isn't infringing on someone else's trademark. So trademarks, on the other hand, are property. And the owner of the trademark has the exclusive right to the trademark and can prevent another individual from using that trademark. So a trademark is not limited to a business name, but also includes a phrase, a logo, symbol, design, image, or a combination of these elements. And this mark cannot be similar to any other trademark. So clients, too, they're often confused as to whether they should register their trademark with the state or with the federal government. And this often depends on their business needs, where they're doing business, and how much money they're willing to spend. So the differences are that the state, with registering with the Minnesota state government, the mark must be used within the state before it is registered. That's the most important part of trademark law, is that the mark be used in commerce. And within state registration, even if it's used, let's say, in a specific geographic area such as northern Minnesota, you'll only get protection within northern Minnesota, not within the entire state of Minnesota. And there's a small filing fee. It's $50 to $70 per class, as compared to federal registration, which is $325 per class. And the client may, depending on what type of products or services are providing, they may need to register with multiple classes. So classes could include kind of T-shirts or services or chairs. It ranges all from many different products and services, and those are defined at the Minnesota Secretary of State website or the USPTO website. And so for the state registration, it's a quick review process as compared to federal, which can take a couple months. And with the state registration, it provides constructive notice to those considering using a similar mark in the geographic area in which the mark is used. So again, if the mark is only used within northern Minnesota, it provides notice to companies in northern Minnesota that the mark is valid and registered. And with the federal trademark, even though it's more expensive, you get better protection. So you have constructive notice nationwide that those considering using a similar mark are on notice that you have registered your trademark and it's valid. And there's also greater remedies available for federal registration, including statutory damages and attorney's fees. So again, the most important factor for trademark is the fact that it's used. You get the rights by using the mark in commerce, and these rights are maintained by continual use of the mark. And so for more information, always feel free to check the USPTO website out. And another common question that we get at the brief advice clinics is on domain names. Some clients think, as we saw in the mock interview, that registering a domain name means that they've registered for a trademark, but that's not the case. So when choosing a domain name, clients should do a Google search to see what's available, And they should also check the USPTO website or their state Secretary of State website to see if they're infringing upon anyone's trademark with their domain name. And again, domain names get taken very quickly. There's actually businesses that their sole purpose is to register domain names and sell it at a higher price. So it's important that if it is available, that they do it right away. And this is inexpensive, as I said. They can go to GoDaddy.com, Moniker.com, and it's approximately $10 a year to maintain the domain name. All right. And copyright law also comes up a lot in brief advice clinics. And copyrights protect books, movies, sculptures, buildings, computer software, and pictures, for example. So copyright protects the exclusive use of original works of authorship fixed in a tangible medium of expression, including written, audio, or visual works, and protects the work from being copied by others for a period of time. So the copyright exists automatically at the time of the object's creation, meaning the time when it's first fixed by the author in its tangible form. So although it's not required, registration of a copyright with the U.S. Copyright Office is recommended. And in order to prosecute an infringement action in federal court, a registration must be granted. So the application fee is relatively inexpensive. It's $50 excluding legal costs, but we do recommend assistance of capable counsel for registration. And it's generally recommended that all published works contain the official copyright notice. So this means a C symbol with the date of the publication and the name of the owner. And this is an inexpensive way to potentially deter infringement. And so, for example, we had one client that came in and she wanted to copyright her greeting cards. And so we recommended to her that on the front of the greeting card, on the image that she created, to put her name, the date it was created, and the C symbol. So that's a very inexpensive way for her to protect her work. And another question that we get in terms of copyrights is clients think they can just go on the internet and take any image they see and use it at their leisure, and that's not necessarily the case. They can use images that are in the public domain. And public domain means that really old works like Shakespeare or Beethoven, or a work of the federal government, or work that's been dedicated by the public domain, to the public domain by the owner. And they should also, though, acknowledge the original author when they do this. If it's not in the public domain, they should get consent from the original author. So the key point to drive home with clients is that they're not able to take any images or anything they find on the internet and just use it whenever they want for their products or services. So lastly, we'll talk a little bit about pens. And a pen is more about functionality rather than idea. There are 3 statutory requirements to a patent. There's novelty, utility, and non-obviousness. So pen protects the exclusive right to use a patented invention and confers legal monopoly on the patent holder for a period of years. So utility patents provide protection for about 20 years, and design patents provide protection for 14 years. So the patent owner has the exclusive right to exclude others from making, using, offering for sale, or selling the invention throughout the United States, or importing the invention to the United States. And so for purposes of the clinic, because primarily most of you are corporate attorneys, it's important to inform the client that obtaining a patent is a detailed, lengthy, and costly procedure. So it can take years to obtain a patent and tens of thousands of dollars. And so the business owner should obtain the assistance of capable patent counsel to assist in determining the patentability of the inventions and guide the business through the patent application process. So that's the basics of intellectual property law that you need to know for LegalCorps. Again, in the Starting a Guide to Business in Minnesota, they have great resources for kind of general overview of trademarks, copyright, and patent law. And there are always resources to help you in providing your answers to your clients. So thank you very much, and John will be discussing employment law and real estate issues. Yes.
Sites that you've identified there, it's really important that people use the right domain, the .gov for patent office, because people will do .com or .org in order to promote things, promote themselves. They may not be legitimate. We don't, it depends. So it's very important that they get the exact website.
Of .gov, yeah. And those should be in our handouts and in the Starting a Guide to Business.
Repeat what you said.
So just
Yeah, the point was that when people go to these government websites to look at, it was mainly USPTO, that sort of thing, that a lot of people who are looking for information will do .com just out of habit, and then you get maybe a private company that's trying to take advantage of those letters, as opposed to a .gov that's the real governmental site. So people should be careful about what website they go to.
And those types of imposters don't end just there. Even when it comes to renewing, say like a trademark, you'll get the clients oftentimes will get official-looking documents, which actually aren't from the USPTO, or so just be aware of those things. Employment considerations. I would say this is one of the other key aspects that you'll see with clients that come into the LegalCorp clinic. Is in fact, I just had one of these approximately a month or so ago at the St. Paul clinic. They come in and they say, John, I got this contract off the internet and I've tweaked it a little bit, and here's my independent contractor agreement, and I'd like to have it signed by all the people working for me. And I say that very carefully when I say working for me, that the client here was basically treating what we're going to be employees as independent contractors, and as a lot of you know, this is one of the main areas of enforcement by governmental agencies right now, that the default rule is that you're an employee, that you have to be very careful when you have an independent contractor, that usually they are very short in duration. A lot of companies are going, the rule of thumb used to be about 1 year. Now I've even heard about 6 months with some companies saying that contractors can't go past 6 months. And oftentimes it has to be in an area of work that isn't the core business of the company. So if you're bringing in an IT consultant, that can be an independent contractor. But if you're bringing in a sales rep to sell your medical devices, more than likely they should be treated as an employee. At-will employment is a default rule here. You don't need to have an employment agreement. And depending on how you counsel clients, some attorneys even say, we recommend that you don't have an employment agreement because it mucks up this idea of at-will employment. Other things that you can do if you decide you don't want an employment agreement is that you can have an offer letter saying you are offering employment to someone. You can also decide that you want to do a formal employment agreement, which is fine too, but you should also make sure that you have termination provisions within that employment agreement that allow the employer to terminate the services of the employee for cause or no cause. And there may be different terms within the contract about that. Employee handbooks are another key issue, and most clients that I've ever dealt with as part of LegalCorp don't have employee handbooks. I think that's probably the most common thing, is that they don't have the handbooks. But a thing to keep in mind, if they do have employment handbooks or policies, that they should have a phrase or a disclaimer in it saying that the handbook is only a handbook, it is subject to revision, that it's not a contract, and it can be revised at any time without notice. Minimum wage and overtime, a common pitfall of small businesses and large companies alike, where they will misclassify someone as an exempt employee, basically to not pay them overtime, and still work them in excess of 40 hours a week. And as many of you know, 40 hours a week is the threshold limit under federal law for when you have to pay overtime. Be very careful in this area to counsel people that the default rule, again, is that they are non-exempt. And so if someone is working over 40 hours a week, they need to be paid overtime. And on top of that, if someone is an exempt employee, you also have to be very careful about minimum wage issues. In the event someone's actually working 60 hours a week, but they only made $300 for the week, or $200, whatever it is, you do have to be careful that they are being compensated at least at the minimum wage threshold. And there are federal regulations that will set forth the different methodologies on how you determine an exempt versus a non-exempt employee. We discuss at-will employment as a general rule, but what's chipped away at the at-will employment doctrine are anti-discrimination laws. And obviously there's debates on both sides on whether they are serving, I think most people would say that they're good, but on the downside is that it does chip away at the at-will employment doctrine. So in the event that someone is seeking to terminate an employee, they need to be very careful that they're doing it for a legitimate and non-discriminatory reason under both state and federal law. And there are different thresholds for how many employees that a company may have for federal law to apply. However, for state law, As long as you have one or more employee, you will be subject to the Minnesota Human Rights Act, which includes things, I believe, race, religion, creed, and also sexual orientation is one of the items protected under state law that actually is not protected under federal law. Additional things, this is a major pitfall that I've seen with respect to employers when they terminate an employee or an employee resigns, is the prompt payment of wages. But it also applies to current employees, is that you need to make sure that you're paying them pursuant to Minnesota Statute Chapter 181. Long story short, if someone's going to be terminating an employee, they need to, my advice to the client is have that final paycheck in hand and give it to the employee on their way out. And that way there can be no questions asked about whether they were paid on time. There's some pretty strict liability penalties for employers that don't pay within a 24-hour threshold after an employee is terminated. There's obviously workers' compensation and payroll tax issues. Those are issues that usually I will address with a client and recommend that they either work with a CPA or a payroll service to work on those issues. Most companies are, with respect to workers' compensation, will want to be purchasing insurance rather than being self-insured. Self-insured workers' comp I generally see with much larger companies. Real estate is another area. Yes?
One related question that I know arises at the big advice clinics sometimes has to do with someone thinking about starting their own business who has a non-compete agreement. What should they tell them?
Great question.
Yeah.
In fact,
Oh, you want to?
Michael Vitt raised the issue of a non-compete agreement that someone might be subject to, and what advice do you give to them when they're asking you, hey, I've got this non-compete out there, but I want to start a competing company. We discussed this briefly before. My general advice is, A, asking them if they actually have the contract, and I can look at it and read it and see what the terms are. B, you can discuss in generalities about the issue of scope and duration of the non-compete, that they have to be reasonable. They are disfavored under Minnesota law. Generally speaking, if you have a non-compete that's supposedly going to be enacted for over 1 year, a court might strike that down. If you have a non-compete that says you can't work anywhere on earth, that's not going to be valid either. And believe me, I've seen some of those. They're interesting. The other thing, too, is determine where that non-compete has been signed. If you're under Minnesota state law, courts can do the blue pencil doctrine where they'll actually modify it to a more reasonable restraint. If you're in another state, there are some states that if there's any invalid provision, the whole thing gets washed away. So obviously something you can bring up. I think it usually goes beyond the scope of the 30-minute clinic in terms of the analysis, but mainly just raising the issue that there is a risk there, no matter if the non-compete is enforceable or not, that the former employer may come after the person.
But it's a good point that if they have the agreement, I mean, again, in a 30-minute session, you're not going to go through the entire document, and sometimes people have unrealistic expectations. But usually there are a couple of places you can spot check, and even apart from advice on what the legal ramifications might be, you might spot things in the agreement that narrow its application, or at least can clarify for them what its application is supposed to be.
Another thing, you can also point out that the major risk, which is if you start attacking and stealing existing clients of your former employer or poaching their employees, there's a much greater risk that there's going to be some sort of lawsuit filed by that former employer.
Right, that's a really good point.
With respect to real estate issues, the most common issue that, at least personally I've seen, and I think is common to most other volunteers, someone comes in and says, I'm thinking about leasing some commercial office space. Can you help me, with this? I've got the lease here. Can you look at it? Or what are some of the pitfalls I should be careful about? Ultimately, a written lease is advisable. You're going to want to make sure that there's something down on paper about what the general terms are. Depending on how sophisticated landlords are, I've seen leases that range, surprisingly, from 2 pages all the way up to, I think the longest one I've seen is 79 pages, minus the exhibits and the attachments. Long story short, you want to be advising clients on what is their liability on payment of rent per month, and does that include or exclude common area maintenance, utilities, taxes, other items like that. That is the major issue that I see relatively unsophisticated clients having issues with is, well, the landlord told me my rent was $1,000 a month, but when I got my invoice, they're asking for another $450 to cover utilities and taxes and everything else. So those are major issues. Obviously, you want to know about the term. Are there renewal options involved? Big one is our personal guarantee. That is sometimes an issue that you can negotiate away if the client is supplying a larger security deposit or perhaps a letter of credit. More and more I'm seeing landlords demand both a personal guarantee and some additional form of security, including a letter of credit or a credit check. Depending on what side of the issue you're on, you can argue whether that's reasonable or not. But these are just bringing up the issues, oftentimes for the client to consider. And at the end of the day, it's a business decision for them to put pen on paper and undertake that liability.
Great. Maybe, John, since we have a couple extra minutes on real estate, I don't know if it ever comes up. I've had a few lessees that just want to terminate the lease. I mean, for whatever reason, they just need to leave. They can't afford the rent, whatever. And they may have a personal guarantee, but is that something that you advise people on?
Yeah, I have not dealt with that situation at LegalCORP, but obviously I have seen that situation arise in my private practice. Again, it's one of those deals, just because there's a personal guarantee and just because there's liability under the terms of a commercial lease doesn't mean that the landlord's going to have a collection action commenced against your client. So there may be ways to negotiate with the landlord and have them release the claims for an early termination. There's also issues, too, with respect to a personal guarantee. If bankruptcy comes up, and those are issues you may deal with, and we haven't discussed here today, that's something to refer to a specialized bankruptcy counsel about how filing bankruptcy individually may help prevent any sort of collection action. But again, it's a business decision. You try to go by the terms of the lease in terms of what the termination provision says. Oftentimes, you'll have to provide advance notice. If there is an allowance set in to the agreement that allows you to terminate early, you may have to pay some additional money as part of that as well.
And it's interesting, I've been volunteering at the St. Paul Clinic since I think 2005, 2006. So the first couple of years, the questions that came up were people wanting to start a business and, boy, I've got this great opportunity. And then there were about 3 years of I need to terminate my lease, or the creditors are chasing me, or whatever. And the last couple of years have been back to people wanting to start businesses, but maybe they've been laid off for a few years, and they're, so it just you do get, by volunteering. I mean, one of the nice things too is that you may get a better picture of what's going on out there than, I guess, the general category, either of clients of major law firms or people you may encounter in a in-house group.
And perhaps I missed the easiest suggestion in the event your client wants to terminate early, which is find a replacement tenant. Can you sublease the space? Can you find a replacement tenant for the landlord? Under Minnesota law, a commercial landlord has no duty to mitigate their damages. So your client most likely is going to be on the hook for the remainder of that lease.
Yeah, absolutely. Okay, question?
I volunteered online, and a lot of questions come up regarding bed bugs and mold. And do you find those kind of questions? Are there any provisions that have been drafted or that sort of thing regarding these issues?
Right, question about, mold or bed bugs. Probably in a commercial setting, it would be mold or uninhabitable, space.
I don't think as part of LegalCORP that we have anything. That's one where you get to think on your feet. You can discuss constructive eviction. Depending on what the lease says, there are issues of whether you could hire an exterminator to come in and kill the bugs, or the anti-mold people come in and mitigate that, and whether you can offset the rent payments. There are some commercial leases that say you have no right to offset, and so it's actually a breach of the lease to do that. So you still have to pay your rent and then follow up later against the landlord.
Are there good referrals to make regarding rights?
in terms of referrals to other attorneys or other informational resources?
Informational resources.
Again, there's a place in the Guide to Starting a Business that has numbers for all sorts of state agencies, and that might be, if it's really a bad situation, maybe the Attorney General's office has some help, and if it's a really bad situation, maybe there's a volunteer attorney who could take it on full representation if the client meets the income guidelines. Great. Any other questions? We're going to get set up for our ethics portion. So Mike Vitt is coming back, and